Back on this idea of structure, we want to spend some time talking specifically about that second level on the federal side. So your second level of court is called a circuit court. So this map shows you the circuits in the United States. They're not equivalent in terms of number of people, obviously. They are not equivalent in terms of land size. This is not like redistricting where you have to have that sort of thing. All it means is that, like, we reside in the Fifth Circuit. And so if you go back to the situation with Karen, so she was found guilty and she would appeal to a circuit court, that means that she would appeal here in the Fifth Circuit. And then when the Fifth Circuit makes a decision, that establishes a precedent for all of the Fifth Circuit. So Mike, you used the word precedent earlier. Can you tell everybody what that is?
I mean, it's just once the court's made a decision, that can be used for future reference in any other court case.
So it's a rule. It says that in cases involving the Sixth Amendment, the rule is that attorneys must be competent based on that decision that I used before. You guys learned tons of precedents. Every time you have studied a Supreme Court case and there's a phrase you had to memorize from it, they said this was the message, that is the precedent. So the precedent of Brown versus the Board of Education was what? Say it again, racism is bad. You have to, that segregation is inherently unequal. Yes, Mike?
Is there not a District 12?
No. I had to look. There are, the Federal Reserve has 12, right? I've had people before confuse that, like with the number of circuit.
None of them have a District 13.
Is that I don't know. I don't see a 12. Anyway, I can double check. It doesn't really matter because the concept is this, right? So that's your circuit. So one of the things that might cause the Supreme Court to get involved, well, what if things are different? So if down here, if Kieran is told, yes, you're going to get out of jail because you didn't have a good attorney, and then you've got some kid up here in Wisconsin who did the same thing and they're still sitting in jail because their circuit court said, no, you don't deserve a competent attorney, that could be problematic, you know? There might be circuit conflicts that are fine. There might be situations where you're like, it's okay that they do that in the Fifth Circuit and we do something different in the Seventh. But for the most part, well, not for the most part, in some situations that are really fundamental, we want those things to be administered fairly. So that's a component of the certiorari process. Okay, so you can say this certiorari, or you can just say cert, which is what we will do from here on out. Okay. So the cert process is looking specifically at why would the Supreme Court take up a case. If they are going to take just a handful, I mean less than 1%, there's got to be something really special about the cases that they take. I'm going to show you some statistics. Please don't feel like you need to write these down. I just want to kind of walk you through it. So every year, there are about, like I said earlier, 8,000 to 10,000 cases that the court will be asked to hear. That's a lot of cases. There are two kinds of petitions that can be filed. It costs you $300 to file your petition with the Supreme Court, and that asks the court to hear your case. That makes up a pretty small percent. Okay. There's also a kind of case called an IFP petition. I just think this is really interesting. It's people who don't have $300. They're still allowed to file. It can be handwritten. They might not have had an attorney. So Kieran's sitting there in jail and she's like, I think that this is important. So she gets some prison stationery and she like writes out her petition. Today that makes up a very small percentage of cases. That's not always been the case. There was a time period where the court was super protective of the rights of the accused. And so a lot of the decisions that protected the rights of the accused were established during that time. When Chief Justice Earl Warren was there, he would have the clerks that work for the court, he would have them take those IFP petitions and rewrite them from a very legal, scholarly perspective, and then many of those IFP petitions were granted. But today it's a little bit different. So here's what happens then. So we got 10,000 petitions that have come to us. All of those petitions have to be read, all of them. This is a lot of work. So each of the justices gets 4 clerks that work for them. Clerks are people that went to the very best law schools. A lot of times they hire people that went to the same law school as them That way they're like-minded, you know, they were like the best students of their favorite law professors, things like that. It's a huge stepping stone into being a federal judge. Eventually, our current Chief Justice did clerk for Chief Justice Rehnquist years ago, so they really understand that. I love this. Some of the justices allow their clerks to divide the work. So, like, if you guys were clerks for Thomas and you guys were clerks for Sotomayor, what they might do is allow you to divide the petitions amongst you. Other justices, like I think Justice Alito, doesn't let his, and so they have to work together and read all of them just for him. So it just depends on who you work for. But what they're going to do is they are going to generate a list and give it to the Chief Justice, and they're going to say, these are the cases we think you should consider. That doesn't mean they're going to make a decision. It just means that they're cases they're going to talk about hearing. This is super important. All cases generated by the Solicitor General are automatically discussed. That doesn't mean automatically granted, but automatically considered for granting. The Solicitor General is somebody that works in the executive branch. Think back when we talked about the cabinets last class. So the Department of Justice. So the Solicitor General is the liaison from the executive branch to the judicial branch. If the United States is a party and involved in something before the Supreme Court, the Solicitor General is the one that argues that case. That I've always heard the nickname for the Solicitor General is the 10th Justice. Your textbook calls it the 9th and a half. I can't even say that. 9 and a half. How do you say that? 9.5. Do you see what I'm saying? Yeah, I can say 9 and a half, but 9.5. Yeah, there you go. So that's what. Hence why I like to call the 10th Justice, but they're not really a justice, but there's a really significant relationship there. Okay. If your case involves potential of you receiving the death penalty, they automatically discuss it. Doesn't mean they grant it, but they automatically discuss it. What?
Why?
I didn't hear what you said.
I said that would save a lot of time if we didn't have capital punishment.
Save a lot of
It
time.
would save a lot of time if we didn't have capital punishment.
Because we wouldn't discuss it?
As far as appealing those cases.
Yeah, you're right.
Well, but they would still end up taking the amount of cases that they take now.
Yeah, they could take other cases though. It's more efficient.
All right. 4 of the justices agree to hear your case. You got it. There is not a set rule on the number of cases that they're going to take. The certiorari conferences are done in private. We don't have a record of them. From what I'm told, the clerks aren't even allowed there. It's just the 9 sitting around a table talking, looking at that discuss list. And even the way in which they'll discuss, it's kind of cool. Like the Chief Justice, their vote doesn't count more, but they're like the manager. They're going to set the culture and the tone. You know, so if they want to let everybody talk, or they want to let everybody question, or they want to let somebody dominate, just however they're going to handle it. Why do you think, Chris, why do you think it would be important to have their votes be secret? Like we don't know how many said what, or there's no record of it.
So that way, like, politics doesn't get involved with it.
Okay. Always a good answer to say politics isn't part of it. I like that. Mike.
Is it maybe, I don't know, you don't want everyone knowing what criminals you voted for and against.
Why?
That's dangerous.
Yeah.
Protecting their reputation.
Definitely. I mean, have you guys ever said something that people know and then later you regretted it? You changed your mind? You know, ever had a heated discussion and you think differently than you used to think? I mean, that's the thing is, I think it's really important for our justices not to do that because they're supposed to be administering justice. They're supposed to be making these personalized individual decisions. So having a record of that might threaten that. You know, it might challenge that concept.
It also probably make them, like, more reserved to thinking differently from people.
Absolutely. I think that's a really good point. Uh-huh.
And isn't the whole point of the Supreme Court to kind of protect justices from that? Like that's why they have a life.
It should be, yeah. I definitely agree. All right, so on the screen I have a list for you. The reasons on the left, under the happy face, are reasons to grant cert. On the right-hand side are reasons to not grant cert. this is not in a rule book somewhere. Like, it's not like they have these written down and they're like, oh, there's a hypothetical, so we won't. It just means that over hundreds of years of history, this is what we find. These are the kind of cases. So this is the reason that they probably do. This is the reason that they don't. So, circuit conflicts. Nikita, what is a circuit conflict? Think back to that map I showed you.
So it's something, is it like a civil, argument between like the federal government and states?
Well, close. I mean, if you think back to like this map that I showed you guys earlier, circuit conflict is where the Fifth Circuit is doing it one way and the Third Circuit's doing it another. And we decide, you know what, we don't like that. We want that to be something that's consistent across the country. Not all circuit conflicts necessitate cert. It's just ones that we think need resolution. All right. Multiple amicus briefs. Gabby, what's an amicus brief?
It's when the interest groups can write about or against the case in a specific.
Awesome. Friend of the court briefs. So interest groups are attempting to influence the court through written briefs. So we talked before about how they would try to influence decision making. They also try to influence granting cert. So they will write briefs to try to get the justices to take a case. And this is like if it affects a large number of people, that just means there's a huge application for it. There are a couple cases where the court really wouldn't have a choice. They would have to take it. The example that always comes to mind is the Bush versus Gore case for the election of 2000. The court couldn't have just said, sorry, we don't want to rule on that. Like there's no applicability. I mean, because we needed a president and we needed resolution. So on occasion there'll be a case like that. I forgot to mention this earlier, I think, but if you think back to that circuit map again, as they're divided out, the justices also are in charge of overseeing one or more circuits. So it's like their job to kind of pay attention to the cases that are coming through. That's important because it kind of lets them know and anticipate what's going on. So like this last summer, the court ruled on same-sex marriage. It's not like that's the only case that existed. They only challenged to same-sex marriage. I suspect that the court was very selective about the case when they made the decision that they made, because they were anticipating what was coming. They want to make sure that they make the decision in a case that's going to be like understandable and received. If it's super complicated and it doesn't really fit and there are other options, then they could choose those options as well. And sometimes they'll lump cases together. I don't know if you've ever seen that before, like where you'll look at a court case and it'll have several names listed. That's why, because they're all the same issue, so they can kind of put them together. What does this mean? That you have to have standing. Megan, what do you think?
I'm not sure.
Well, what do you think it is? You have to have standing to participate.
There has to be something for them to rule on, I guess.
Okay, that's close. Standing means that a person can only participate in the lawsuit if it directly affects them. So to have standing means that you are a party. So let's say that I think Texas high school graduation requirements are horrible and they're a violation of your civil rights. So I can't file a lawsuit because I'm not affected by that in any way. I'm not a party to that. So that's why we talked about a while back with the interest groups that they would use the litigation tactic, and I would find one of you who was willing to fight the lawsuit, and then I'd give you the money to kind of walk you through it. This is very important. The court does not just talk about political issues. They don't hypothesize. They don't rule on things that aren't